Good evening, everyone. How are we all doing? I trust that we're doing well. Thank you for joining us again this Friday. I can see that our mentors are here. Hi, Pooja. Good evening, Mr. Max. Thank you very much for joining us today. Hi, Augustine. How are you doing? And for every other person that is here, thank you. You're welcome. Oluwafemi, thank you. Thank you all for logging in early today. Okay, so hi Precious. So see, we are all looking good. So we know that today we have two special mentors, Pooja and Mr. Max. My name is Juliana Imam. Good to see you, sir. Good evening, sir.
Thank you, Juliana. I made sure my cap came into the picture today.
Yes, so you're looking good. Thank you, everyone, for joining us today. So the topic that we'll be discussing today is an interesting topic, and I'm sure that we would all enjoy it because the mentors that we have today are interesting and very knowledgeable people in this topic. So I'll be going straight to read what we are about, which I know that we already know. Okay, so about the program, Gypsy Intellectual Property Mentorship and Internship Program is a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for Gypsy on YouTube and Facebook. Our hashtag is hashtag JIIPCCMip. Our objectives: one, to provide and stakeholders to transform mentees into mentors and leaders for the next generation of mentees, and to facilitate further mentorship, internship, scholarships, and job placements for mentees. Also, I would like to encourage us that we should take advantage of the private mentorship sessions. So I know that some of us might have questions, or we might have things that are going on in our day-to-day practice that we might not be able to share while we are online. So if you see any mentor that has come from the beginning of this program to this time that you think you want to talk one-on-one with, you can take advantage of this. That's the private mentorship session for 30 minutes by using the link bit.ly JIIPCC PM. So thank you very much, everyone. So we'll be going straight into the presentations. We have 4 groups: Group 1, Group 2, Group 3, and Group 4. So we'll start our presentation with Group 1. You have 7 minutes to present. Please try to share your slides so that the mentors can follow what you're saying. Thank you. So who is presenting for Group 1?
That will be me, Oluwafemi Ojesho. I'll be sharing the screen also.
Okay.
Okay, so good afternoon, everyone. My name is Oluwafemi Ojesho, and I'll be representing Group 1 for this presentation this week. Our topic for this week is IP for inventors, particularly how innovators in the aviation and automobile industry use IP. So generally, IP generally, as you know, refers to the creations of the human rights, the creations of the human rights, of the human mind, sorry. IP refers to the creations of the human mind, like what you can think, what you can develop, what you can bring into play, what you can contribute towards innovation. And IP is IP is particularly important in the economy because it stimulates economic activity, it stimulates economic growth, it stimulates economic development. The competition between parties, between people, tend to make them more creative, tends to make them put in more effort into developing new technology. So the history of mankind up to date has been one of innovation, one of IP. We went from the Stone Age to the Metal Age, to the Renaissance, to the Industrial Age, and now we are in the digital age. All of these innovations, all of this evolution has been as a result of innovation, has been as a result of someone moving the existing needle forward through innovation. So simply put, an inventor is someone who designs something, who makes something new, someone who improves on an existing design. One of the most popularly known inventors is Thomas Edison, the creator of the light bulb. I mean, he had over 100 patents, and history has it that it was his 169th experiment with regards to the light bulb that gave us the let's say fluorescent lights we have today. So basically, an inventor is someone that creates, someone that innovates. I mean, we have our modern examples of Steve Jobs and Apple. We have Elon Musk and Tesla. And then also, we need to note that in these modern times, the rights to innovations are held more by corporations than by individuals. So a person can be an inventor, and a corporation can be an inventor, depending on the agreement between the inventor and the corporation. Sorry, I stutter at times. So yeah, there are a number of intellectual property rights available to inventors. How they can protect their work. So basically, we have patents, we have trade secrets, we have trademarks, we have design rights, and each of these class of IP rights. In fact, we have copyright. Each of this class has specific rights it confers upon the inventor. So these IP rights allow them to do some things to the exclusion of other people in order for them to get the recognition attached to their invention, and also monetary compensation for the effort and the resources they have expended in bringing these things to life. So moving on to our topic for the day, IP in the aviation industry. So basically, the aviation industry is basically concerned with flights, aircrafts, airplanes, basically anything that flies. So historically, flights, well, let's say sustained flights was achieved with the Wright brothers. Prior to the Wright brothers achieving flights, we had other, well, let's say aviators now, inventing, looking for ways to achieve flights. And these guys collaborated with each other, share the knowledge and all. But once the Wright brothers attained flight, they applied for a very, very wide patent that covered a lot of things, and they more or less looked to enforce their rights, enforce their patent through litigation, and as such, it kind of reduced the steps made in that field. But with the World War II looming, we saw the government mandate all these inventors to pool their patents together so that they can all share from the same pool and be able to make cheaper airplanes, be able to manufacture cheaper airplanes for the war effort. So this more or less gave birth to a regime in the aviation industry known as cross-licensing, whereby everyone shared the knowledge they had. It was more or less like my patent for your patent, my knowledge for your knowledge. There was really no fee involved. The fee was an exchange of knowledge, exchange of this licensing. And that has largely been the case with regards to the aviation industry. One of our case study with regards to innovation and the use of innovation in the aviation industry is Boeing. Boeing is one of the largest commercial manufacturers of airplanes. Boeing and Airbus are the two biggest players in that space. And Boeing, in using their IP, they mostly leverage trade secrets and patents. They look at, okay, is this thing easily accessible to the public? Can this thing be easily seen from what we've put out there? I mean, if it is something that can be easily deduced, Boeing goes the way of patenting. But if it's something that is not readily available to the public, and they feel, oh, we can actually maintain the secrecy of this thing through trade secrets, then they go that route. And then also, one of the things Boeing does is to license their technology to non-competing industries, such as the automobile industries. Given the well, let's say components now that make up an airplane, it's just not the wings, the body. We have the electrical systems, we have the landing systems, we have the brakes. Like there are a lot of components to the overall assembly of the airplane that are also useful in other industries. So as a way of exploiting their IP, Boeing licenses some of these products, some of this technology to non-competing industries, and these guys more further go on to improve that technology, saving Boeing money to pursue that. Okay. So quickly moving on to the automobile industry. Unlike the aviation industry, the automobile industry thrives more on patents and designs. It's more competitive. So we used a case study of Uber and Waymo, whereby one of the engineers working on self-driving technology for Waymo went to Uber, and Waymo sued Uber in that the trade secrets they had in that technology had been tapped by them, and the parties reached a settlement. So usually exploiting IP in the in the automobile industry is more of being competitive, but Tesla did something in 2013, 2014. They gave up their patents to the technology behind the electric car because they felt this is the best way to advance that technology. When everyone has the schematics, as the design, then innovation can move at a much faster space. Now we have charging stations for cars. We have more efficient batteries. All of these arising from that open source move made by Uber. And then also there's also the issue of designs. Car manufacturers protect their designs. Their designs are their brand. They are what make their customers know, oh, this car is a Toyota. This car is a Camry. And we've seen cases whereby other people copy designs and then sell at a much cheaper rate than what the original manufacturer is doing. And this was what happened in the case of Land Rover and a Chinese company, whereby the Chinese company more or less copied their design, used it for their cars, and then we are selling it cheap to the people of China. So Land Rover went against them, sued them, and got judgment against them, thereby enforcing their IP. So in conclusion, basically, it can be observed that exploitation of IP in the aviation industry is more of is hinged more on collaboration and cross-licensing with respect to the commercial aspect, and then with respect to the non-commercial aspect, defense and co. They use trade secrets to protect that, because I mean you won't want the schematics of your military aircraft and all to be out there in the open. And then for the automobile industry, it's more of a competitive thing with the idea of collaboration just coming into play in that space. So thank you very much. Hope you had a wonderful time.
Thank you very
presentation.
Thank you very much, Femi. I actually enjoyed your presentation. So we've had like these sessions for more than a year, and we've been taking this topic, and I think this is the best presentation on this topic. Thank you very much. So let's hear from group 2.
Good evening.
Good evening.
Okay. I will share my screen now, just a few seconds. I don't know, is my screen visible yet? Is it
yes,
visible?
it's visible.
All right, thank you. My name is Solomon Faith. I'm presenting for group 2. Our topic is how inventors in the communication industry use IP. And so basically, I avoided talking about what IP is because we have been dealing with that already for some weeks now. So, but basically it means protecting the ideas and creative works of people. That's what IP is about. So we'll go into the main topic for today, which is how those in the communication industry protect their work using IP. First of all, that's inventors in the communication industry, not just the communication industry, those who invent in the communication industry. How do they protect their work? Our earlier speakers already spoken about inventors. He has dealt with inventors properly, but just to give a small summary from our own side, an inventor is someone who creates something novel, something new, or a new method of doing something, or improves on existing works that have been created before. So that's who an inventor is, or an innovator is. Communication is something that is common to man right from Stone Age, the past ages, human beings have always wanted to communicate. We say human beings are a social animal. So human beings always love to communicate, to interact. So communication is just interaction between people trying to pass across ideas and tell people how they feel or what they think. That's what communication is all about. So communication is something that is very common to man. And like IP deals with every aspect of human endeavor. As long as human beings continue to exist, innovation will continue to exist, creativity will continue to exist. So that means IP is always going to be relevant. And so also in the communication industry, IP is very, very important. But how do communicators or how the inventors in the communication industry use IP? Well, how important is IP in the communication industry? So we just looked at some of the effects of IP, then we'll look at how they can protect their works, and then I'll give a case scenario and I'll conclude. So some of the effects the IP can have in the communication industry, or how it can help innovators in the communication industries. Those, now, first of all, IP is meant for businesses. It's meant to help innovators enjoy the proceeds that come out from their inventions. So in the communication industry, those who innovate, those who create things, will always be looking for a way to make profit out of what they've created. And so it is important that IP covers some of those proceeds that should come, or keep their works protected so that they can enjoy those benefits. So we can see that in the communication industry, in some of the innovators we have seen, inventions we have seen include phones. Phones made it easy for people to communicate for large distances. Someone in Lagos can speak with someone in Kaduna State, for instance, because there's such a creation as the phone. And then social media is also an invention that has made communication very easy. So it's part of innovation in the communication industry. The printing press is part of innovation in the communication industry, where people can write things and pass it across a large audience for people to hear what they have to say and pass across even news and all that. So all these things need protection, all these things need protecting, so that whatever benefit could come from it, commercial benefit come from it, they'll be able to enjoy, those who have innovated in that sense can be able to enjoy the benefits that come from it, and nobody steals their work. So these are some of the effects we see. Filmmakers need to protect their work. Call time providers like MTN, Glo, they want to protect their works. Social media owners, for instance, Metaverse, Facebook previously, now Metaverse, protecting their work. Airing rights. I remember in the first week we did we had this meeting. We had someone speak about how people in telecommunication can enjoy, the benefits with airing rights. He was talking about the African Cup of Nations, how some people have been given the right to air and allow people to view what is going on with the whole sports that is going on there, football sports. So that airing right is a benefit to someone, and that person has gotten the IP protection just to air that event. So it is a benefit that someone needs an IP right to protect. So also, when people use these communication inventions, sometimes they need their works to be protected. For instance, on social media, a lot of people are creating things. People are writing things that should be protected. So you discover that most of these social media apps already have their social media policy, IP policy. TikTok has its IP policy, Facebook has its IP policy. So these IP policies are just to protect those who are already using the platform, to protect their creative works. Take also, for instance, when you make your call between yourself and another person, your conversation is covered, protected. I feel that's also a kind of IP right, protecting whatever things you have said between yourself and another person, not allowing it to be infringed on. So as people use these devices, also their IP rights are also protected, their innovations are also protected, and all that. So that's how IP invades this space of communication. But how inventors in the communication industry also use their IP. We can see inventors use IP to protect the technologies they create. I've spoken about that. For instance, the virtual assistant in the Apple phone, which is called Siri. There was this little issue between a Chinese company and Apple, a little issue on it. I saw the case online. I cannot really give the details because of my time, so I'll go for that. They can also use IP to protect users of their technology, like I already mentioned. Might need some protection like trademark, service mark. I didn't add some other things. The copyright also is very important for protecting communication inventors. Also patents, very important for communication inventors. In Section 1 of the Copyright Act, one of the items that are protected by copyright is broadcast, I think cinematography, something like that. I can't exactly remember the name, but it has to do with communication using broadcasting elements like the, TV and all that. So it's covered by copyright. Also, probably a business owner might want to protect his service. Apple, for instance, want to protect their brand name using trademark, or if it's a service provider like MTN providing communication services, they might want to protect their service mark and all that. Then patents is always very important for an inventor. Anyone who is into invention will always need patents to protect his work. So all these IP rights are very important in the communication industry. Inventions are protected from counterfeiters using IP also. So it's very important. Then some issues inventors in the communication industry face when it comes to IP includes patent tickets. Is when there's so much patent on a particular, different companies are trying to have patent on a particular invention, and because they see that there's this competition, they try to have the patent on that invention and limit another company from trying to, develop in that space and, invent in that space. For instance, in phones, there's always invention going on because you are improving on product and continue improving that product. So they're trying to have the space of market for themselves and then try to limit other people from coming into that space and, taking over or making much profit there or taking their own profit out of the market. So that patent ticket is a very big issue. Cross-border IP laws are also issues. Then difficulty sometimes in enforcing company IP policies can be met by IP inventors in the communication industry. Our case scenario deals with the case of Samsung and Apple. They had a very huge issue between each other. Samsung created a device that looked exactly, that's a phone device, which is for communication. They created a phone that looked exactly like one of Apple's products. And so Apple took them to court and won the case for, I think, $1 billion. But Samsung appealed, and they kept appealing until they got to the Supreme Court in the US. But finally, they decided that they would settle out of court. So they're able to settle out of court. And when you make ADR settlements, most of the time they are secret. So I could not find the details of what happened after the settlement, but they've settled out of court for that issue. So this is a scenario of someone having invented something in the communication industry, and then it was infringed. That right was infringed, and if they don't have access to IP to protect that work, they might not be able to sue and then protect their invention from being infringed on. So IP remains very important in the communication industry, and I hope with this little presentation we've been able to learn one or two things. Thank you very much.
Thank you very much, Solomon, for your presentation. I also enjoyed it. Thank you. Thank you for the work that you've put into this.
Thank you, ma'am.
Yourself and the group, and thank you. So let's move to group 3.
Good evening, everyone.
Good evening.
Please, can you hear me?
Yes.
Yes, we can.
Okay, my name is Omolola. On behalf of Group 3, And our topic is medical and pharmaceutical industry. IP in the medical and pharmaceutical industry. So I'll start with the introduction. Okay, so intellectual property generally refers to the creations of minds, while IP rights usually refer to an individual's right to own and benefit from the work they create. So this is something that we have been saying for the past 2 to 3 weeks. So I believe that we are all acquainted with this particular meaning. So intellectual property rights are commonly seen as one of the most important economic assets of any corporate entity or research organization. So what we are talking about today is the intellectual property. Intellectual property is very, very relevant in this industry because sections support its investment into medical research. So without patents, without intellectual property, most especially patents, medical practitioners and pharmaceuticals will not be motivated to research, not be motivated to invent new things for people to use. So developing a new drug and successfully bringing it to market is risky, lengthy, and expensive venture. It is largely recognized that pharmaceutical IP rights are essential for the continued innovation of new medicines and therefore exist in the interest of pharmaceutical companies, patients, and society at large. Like I said earlier, it is very, very important because it encourages them to continue producing these things, because when you produce drugs, it's very, very risky. It takes time, it takes effort, it takes energy. So when you grant them this right, most especially patents, they will be encouraged to do more. So yeah, the 4 main types of IP that are generally encountered are patents, trademark, industrial design, and copyright. But like I said earlier, intellectual property is more visible when it comes to patents in the pharmaceutical industry. So how IP right is manifested in the medical or pharmaceutical industry? So let's start with copyright. Copyright, unlike trademark and patents, copyright need not to be registered to be enforced. So in the pharmaceutical industry, where exchanging information about the latest medical and scientific advances is critical, it's easy to breach copyright laws by inadvertently copying and sharing content without permission. So the chemical structures and equations are not usually considered for copyright. So the structures, the equations, everything that they do in order to achieve their aim, in order to produce a medicine or any other thing, cannot be protected under copyright because there are only few ways to write it down. Copyright must be written. Anything you want to own as a copyright must be written down. So in this particular scenario, you cannot write down these equations, cannot write down this chemical. So that's why it's not really advisable to protect these things under copyright. So when I move to trademark, a trademark protection can find expression in the company or a mark engraved on the surface of drugs or something else. So I'll just end with trademarks because most of these drugs, the names of the chemicals. So it's a generic term, it's a generic name, so it's not unique to them. So that's why most times they cannot protect these drugs, they cannot protect these things under a trademark. So for example, according to the slide, for example, oxydicyline in respect of chemical compounds, because oxydicyline consists of the commonly used name for a chemical compound having the formula Si2H2O. See section 12 of the trademarks. And like I said earlier, all these drugs, they are like a combination of different chemicals. So they just name them according to those chemicals and they are generic names. So you can't just come and say that you want to trademark this name because it's a drug. That's why patents are used most times. So yeah, we talked about the conventional justification for trademark protection is that trademarks not only minimize consumers' protection, but also ensure manufacturers maintain consistent product quality. Okay, one of the reasons for trademark, for example, Coca-Cola, one of the reasons is that, okay, people will be able to trust them to continue to produce drugs with good quality. But when it comes to pharmaceutical trademarks and trade dress, they are performing the opposite functions. Instead of reducing the customer confusion and enhancing market efficiency, they are usually actually confusing patients into believing that trademarked drugs are distinct medications, leading to wasteful spending and even substantial morbidity. So this is the explanation of this thing. The reason for trademark is to continue producing quality things. So now, patents, all these drugs, they are not essentially doing this, they are not essentially performing this role, because when you continue giving names and names, people will think that, okay, this one is different from this one, or this one has more quality than the other, whereas it's still like the same chemical, it's still the same thing that they're using to produce certain goods. That is certain medicines. That's why patent is like the most important thing to use in the medical and pharmaceutical industry. So I'll move to conditions qualifying a creation under medical and pharmaceutical industry for protection. Yes, the law on intellectual, please move to the next slide, Chair. Yeah, the law of intellectual property differ from country to another, from one country to another. Thus, what can be protected in a country might not enjoy the right of protection in another. We sometimes encounter individuals who perceive themselves to be creators and inventors with new groundbreaking discovery, which they claim can solve certain problems. So there are different laws guiding patent law, there are different laws guiding intellectual property. The laws in Nigeria might be quite different from the laws in Kenya. The laws in Kenya can be quite different from the laws in Ghana. So now, want to look at the Patent and Design Act in Nigeria. So the first thing is that the invention must be new and have an inventive step that is not obvious to someone with knowledge and experience in the subject. Now, when you want to create something that you want to, that needs patents and design patents really, that invention must be, and the inventing step must not be obvious with someone, not someone with knowledge and experience. Subject. Something like, okay, if I'm a doctor, my fellow doctor, my fellow medical practitioner should not have knowledge of that thing. It should be something that is new, that nobody has seen before, nobody knows the inventive step. So so just like it is there, the invention will not be against public policy. Anything you are creating, anything you are making, any new thing you are making must not be against public policy. It must be accepted by everyone. It must be accepted by the public. And the third one is full description. This prescribes that the application must clearly and fully disclose the details of the invention, the processes involved, and okay, sorry, I will continue from I'll continue from there. Something not okay. Okay, so I'm sorry for the network. Okay. The full description. Now, the invention must not be against public policy. So I've said that earlier. And the last one is that it must be capable of industrial application. Yes, it must be capable of industrial application. It must be used. You cannot just create something that cannot be used by anyone. It should be used. It should be able to be used by everybody. People should be able to see this and okay, it is used and use it for different purposes. So please let's move to the next slide. Okay, thus as it concerns the medical and pharmaceutical industry, a drug is patentable if it is not obvious, new and useful. The drug must be non-obvious, another previously invented. So the whole idea of this is that it must be new and it must be non-obvious to someone that has a general knowledge about it, and it must be useful. Okay, so yeah, under Nigerian Patent and Industrial Design Act, so when you want to apply for a patent, number one, your full name, the applicant's full name and address, and if the address is outside Nigeria, there should be an address for service in Nigeria. So the second one is description of the relevant invention with any appropriate plans and drawing. And the third one is a claim or claims for any number of products, processes, or applications. However, an application shall relate to one invention only. So you can apply for one invention at a time. You cannot do two inventions. You cannot apply for patent for two inventions. So I'll move to the conclusion. And the importance of IP in the medical industry. A significant incentive to stimulate innovation. So when you grant patents to people, it encourages them to continue to do more, to continue to produce medicine and other things that will help in the pharmaceutical industry. So it acts as a shield against infringement claims. And yeah, conclusion, around the world, we all enjoy and make use of drugs, make use of things varying from medical discoveries and inventions to electronic are given to develop means and systems to encourage creation, protection, codification of all these things. So basically, I'll just conclude saying that intellectual property, most especially patents, protect the creation of medical systems to encourage them to produce more. Thank you.
The internet, I'm not sure if what I'm hearing is on my end. Everybody is hearing what I'm hearing. But I want to believe that it's the internet that is doing that to us. Thank you very much, Omolola, for your presentation. Let's move over to group 4. Please present. Everyone. Good evening.
Yeah, so this is Samuel. My name is Samuel Abu. I'm presenting for group 4. And please just give me a moment while I share this slide, share my screen. I hope you all had a wonderful week, by the way.
Yes, thank you.
All right, so. Okay, so can everyone see my screen? It's good. Okay.
Yes.
Just give me a minute while I get this up to the set. All right, so good evening, everyone. Once again, presenting for group 4, I'm Samuel Abu. And of course, today we're discussing about intellectual property for inventors. And specifically, our group was told to focus on intellectual property for engineers. And however, what we observed was the fact that group 1 was already talking about automobiles and aviation, then we had communications, and also we focused a bit on automobiles and the software angle to it. So we had to split up engineering into 2 aspects, which is hardware and software. So basically, we all know that intellectual property helps to protect the creative prowess of a person. So we understand the fact that we have 2 phases of creation. The fact that you first think of something in your mind, then you bring it to bear in the physical. So the process of intellectual property is to help you protect the fact that you've been able to express what you thought of in your mind, and then it's now tangible. So IP doesn't protect ideas, but protects the product of the ideas. And so for this presentation, we're categorizing inventors into 2 sectors. And we all know that inventors are people who go out of their way to come up with new mechanisms, new products, or new ways in which you can do stuff. So for hardware, we're going to be taking a case study from Volvo. So ideally, the concept of a seatbelt, for example, was actually patented by Volvo. It's a system where the pressure of a vehicle inhibits the speed in which a seatbelt is laxed. So I think before then, when you're driving, you probably had to tie maybe a rope, or you had to just rely mostly on some other fringe mechanism. But what Volvo did was to come up with a system where you had 3 points that could protect your chest and all of that. But interestingly, what we figured was Volvo actually had to give up this protection because they felt it was much more useful for the public community than to just hold the patent rights to it. So we're going to look into that of Mercedes. So now, why we're doing this is to show the class, or to show the audience, how engineers actually protect their intellectual property. So that's why we're focusing first with patent, covering all of this, because we know that for intellectual property, you have copyright, you have trademark, you have patent, you have trade secrets, and then you have a variation of protection for plants, you have all of that. But for the purpose of this presentation, we're focusing more on the engineering that covers the software and the hardware. So for Mercedes, I think for Mercedes, what I'm going to focus on is going to be the one for the braking system and the deflatable tire. So you can, if you see my screen, you would observe that there's a new patent application that is used by Daimler AG, and they own Mercedes. And what this does is when your car brake fails, for example, you're going at a high speed and the braking system fails. So there is a mechanism whereby Mercedes tires deflate. So once they deflate, it cuts the speed at which the car moves, and automatically the car could stop gradually. So the danger of it is that, if, for example, your tire bursts while you're on the highway, and of course, you're not meant to press your brake, because when you press your brake instantly, it makes the vehicle turn over. So what Mercedes does is that Mercedes tries to put in a system in place where if your brake doesn't work, all the 4 tires deflate. So once they deflate, as they gradually reduce pressure, the speed reduces. Now, I think another part for, yes, another protection model that we have is the industrial designs. Now, so for industrial designs actually apply to every form of intellectual property product. But when it comes to engineering, I think we think it's also one of the very most important things to use, because, for example, every sewing machine, every blender, every car, every helicopter probably have a specific way their manufacturers design them. So, for example, in our case study here, we have Toyota and Hyundai, and then we also have the Ferrari case. But I'm going to focus on the Ferrari case. So, what happened in the Ferrari case is that Ferrari has a particular vehicle called the FXXK. It's a sport car for racing, yeah. And Mansory Design Holdings, what Mansory Design Holdings do is to design the cars for Ferrari. So the problem came up where Ferrari observed that Mansory Design Holdings was using the design for a particular model of Ferrari, which was the FXXK, and was implementing that design on another model of a Ferrari, which was the GT8, which was a 488 GTB. So the issue here was the vehicle Mansory Design is imposing that design on. The vehicle just cost about $250. However, the sport car costs about $2 million. So you had Mansory Design ripping off Ferrari by, what's the word I'm going to use now? By representing a model of a car that was not. So if I'm bringing it to bear, it's like saying Elizade and Toyota, quite all right. So Elizade is to sell Toyota Venzas. Yep. And then you also have a Toyota Camry that has a huge back and stuff. So you now have Elizade representing Toyota Camry as a Toyota Venza. So that way, Elizade was selling Toyota Camrys at the price of a Toyota Venza, but remitting to Ferrari, you get the price of a Toyota Camry. So that's what the case is all about. And that just shows you that for every form of engineering product that you have out there, the industrial design is key, and not just for the hardware, but let's talk about the software angle to it. So same thing you have with, I think this is very, very obvious. I mean, you guys have seen, you've seen the video of people trying to open up laptops, and someone places a MacBook beside a Dell, and then they both close the laptop, and then you have them saying, okay, you know what, I'm going to open the laptop and let's see which one doesn't shake. So you observe that the person that opens the MacBook, by the time you open up a MacBook, it really doesn't shake. But when you're opening up any other products, well, it will always shake. So these are the design components that, you know, engineers have looked into it and they're like, okay, yeah, these are the things that make people want to buy. These are the things that appeal to people in the community. So you see people say that, oh, this iPhone XR looks slick. I just like the design. And some will say, oh yeah, I feel Samsung phone Z Folder is actually cool for me. It's cool. Yeah, so these are all designs that appeals to people, and engineers always protect it through the industrial design. Then the next mode of protection for engineers in the hardware category is also the trademark. So yeah, I think for this one, we had a discussion about this. And for those that drive, if you've driven the Benz before and then you've driven probably any other category of cars, there is this comparative difference you have when you drive a Benz, another category of cars. So when you drive a Benz, because of the way the tires are built and because of the rigidity of the car, if you are going at 120, 140, the car tends to be like rigid and sturdy, so it's not shaking. But if you try going 120 on a Kia Cerato, the Lord help you, as you travel to a safe journey, because it feels as if the steering is going to fall off. But so trademarks help companies to exert their integrity on a product. So it exerts the fact that, okay, this is Mercedes-Benz, this is what we are good for. So this is Ferrari, this is what we are good for. Once you see Ferrari basically represents speed, so you can see the stallion. Toyota logo basically just represents the T and the O, and also the fact that they appeal to the global market. So it has the global, like the shape of the globe and all of that. Then also Honda, when you see an Honda vehicle, although I do not mean to make this a disparaging comment, but for those that drive, if you are driving on Lagos Road or anywhere in Nigeria, and you see a vehicle that the steering, you turn the steering, or a vehicle is parked on the road and the steering or the front tires are turned towards the right, it's most likely going to be an Honda vehicle because they have this issue with their steerings, but you don't find that. So it just tells you that when you associate a particular default or a particular benefit to a particular kind of vehicle, you can tell the quality. And so this helps vehicles and vehicle owners and any other type of engineering product to distinguish themselves with the trademark. And then so we're going to the software category now. So basically what you've seen me explain with regards to patents, industrial designs, and trademark also pretty much applies to the software. So for the software, we're going to take you through other categories. So where we're focusing on the software is that, like I said, the outline for us didn't really specify the part of engineering. We could have picked up engineering in construction or maybe full engineering, but we just felt that if we do hardware software, it kind of like balances it. So for the software angle, wow, okay. So for the software angle, I think it's just going to focus mainly on the fact that we have copyright protecting software engineers. Then you also have patent protecting the way in which source codes are written. So for example, if you use Spotify, there's a product in Spotify that allows you to share your playlist live. And also it allows you to share your music from two different devices. So I could share from my laptop and on my phone at the same time. But you don't have that in Apple Music. And that's a particular system or a particular framework that Spotify alone uses. Then we're going to look at augmented reality and virtual reality. So for augmented reality, what you have is engineers also basically protect this right by virtue of patents, because augmented reality is imposing virtual reality and the physical reality. If it's a very basic example is what I'm doing right now. You can see my background. So of course it's augmented, and you can see that. So you can protect that by virtue of your patent, right? Which Zoom has been able to do. And then for virtual reality too, you have it protected by software, by patent, and even sometimes by industrial designs, because if you're playing games, for example, the way Spider-Man looks in a game has the whole Marvel feel to it. It's different from what you see in a DC game. This for those that play games anyway. And so like we're winding up quickly now. So let me just quickly round this up I'm sorry I took so much time. But yeah, irrespective of the category of engineering you find yourself, if you're building as a civil engineer, as a software developer, as a vehicle engineer, a vehicle designer, whatever it is, their basic applicable is to protect your IP. So you look at the copyright protecting your literary works, protecting your photographic works, protecting your source code, your software, and all of that. So looking at trademarks, protecting your service, protecting your integrity, then patent protecting, the way your system works, the way your application integrates people's information, the way Apple Music integrates data, the way Spotify basically integrates data, or the way YouTube Music is able to create songs to the way you like them. They also have industrial designs talking about how you enjoy the feel. So your UI, your UX, if you're going to product design, all of that. So UI, UX, you're basically covered under industrial designs. The colors, the feel. If you look at Spotify, it's all green. If you look at Apple Music, it has a bit of red and white. If you look at Google, you have basically different colors. If you look at Snapchat, I don't think those ones have colors because they have different gradients of colors. But ideally, these are the ways you protect. And I think another way to also protect it is through licenses and agreements. So for example, if you look at what Mercedes has done, it's possible that Mercedes will license those rights to other vehicles. I know what we know that this can save lives, so we're able to deflate tires, what we're moving. And finally, I think one major tip we can use with regard to license has to be open software license or open source code licenses. That's for software, guys. But most importantly, I hope that pretty much covers I hope I'm still within time, but most importantly, that pretty much covers everything that regards to protection, of your IP rights for inventors. And I think lastly, I want to look at for engineering. So civil engineers, also you could protect your work by virtue of patent. So I'm sure Dangote Cement has his own way of making his cement, and it's kind of different from what BUA does. It's the same. Coca-Cola has this food engineering technique that they won't let anybody know. You understand? So these are all important ways to protect, IP inventions for engineers, and in a way it drives innovation. And yes, so so I'm within time. Thank you very much for listening, and I hope this pretty much covered every detail that you needed.
Thank you very much, Samuel. You spent about 14 minutes when you're supposed to spend 7 minutes, and you now said that you are within time. Well done. You are really within time. Everybody that presented today, you are within time. So I really enjoyed the presentations today. I think that all the groups did amazing today, from group 1, group 2, group 3, group 4. And then the encouragement in the chat box is just amazing. Well done, everyone. So our mentors for today will be making comments on the presentations. Our first mentor for today is Max Ikonbe. He is the founder and principal of Everlaw Associates. He works extensively in the field of arbitration, ICT and technology law and intellectual property. He is a facilitator on the annual Information Technology and Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he's an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business there since 2010. And then our second mentor for today is Poja. Mrs. Poja Kuma is a founder and director of Innovelect LLP, established in 2017. She's also a registered patent agent and startup facilitator of Government of India. She holds more than 15 years of experience in intellectual property rights field. She has won gold medal in master's degree in microbial and food technology from Punjabi University of Patela. Besides that, she has also qualified GATE exam in 2008 and in 2008 and India Patent Agent exam in 2010. She has delivered more than 200 awareness programs related to intellectual property rights. Recently in 2020, she was recognized as top women consultant for her contribution in the field of IPR. She has paneled with Gujarat Innovation Council. She's not only creating IP awareness in India, but also working for international countries. She has received awards and recognition in her professional journey. She has filed more than 500 patents. She has opened various IPR cells in different universities like Subharti University, Murit, MIT, and Swami Rema Himalayan University to Haddon. So thank you very much for joining us today. So I think that we'll hear from Pooja and then we'll hear from Mr. Max. Hi, Pooja. Thank you so much for joining us. You're muted. Okay. Thank you.
Yeah, just Mr.
We can hear you now.
Okay. So I've shared my slide, and it was a very wonderful lecture by all of the group 1, group 2, group 3 and group 4, as I'm working with a lot of universities and I'm working with a lot of innovators and inventors, because whenever any inventor come to us and approaches us that, Pooja, we have an idea. Now you tell me where we can file it, like whether we can go for patent, whether we can go for design, copyright and trademark. Now, whenever you have an idea in your mind, the first important point that you have to keep in mind that what is the novelty of your invention? If the idea is already existing, okay, so we suggest our inventors that you cannot file the same idea because it is already in the public domain. So whenever any idea come to us, and whenever any idea come from the inventor, the first important point is to do the novelty check of that an idea. So to do the novelty check, we have different databases, like we have Google Patent, we have USPTO, eSpaceNet. There are different databases where we conduct the novelty search. And the important thumb rule of the patent is that whenever you have an idea, you cannot file your patent if your idea is already in public domain. So it means that there is no novelty in the invention if you have disclosed your idea in the public domain. So very important thumb rule that you cannot present your paper in a conference or in a seminar, or you cannot publish your paper unless and until you first file the patent for that idea or that research work. Now, whenever you file the patent, the two things are very important. One, the inventor came to you and they said, then my work is it only at idea base. It is not completely converted into a prototype. Now, is that patentable? So in that case, you can file a provisional patent. After filing a provisional patent, you get 1 year time to complete your work. Okay, so means you get one window period, 12-month time to complete your invention. So this is the one important, that you get the priority from securing your invention in the form of provisional application. And after that, you get 1 year time to complete your invention. So this is the one case. Second case, if the inventor has developed any software applications, like already many people in the group have said that we have different types of intellectual property. Intellectual property is a creation of human mind that comes in your mind. Yeah, it can be any painting, it can be any bottle, it can be any device, it can be any composition, it can be any pharmaceutical composition, or it can be any pharmaceutical device. So now this work can be protected in the different forms of intellectual property rights. Like we have industrial property right, patents, trademark, industrial design, and trade secret. That all comes under the industrial property rights. And second is the copyright and related rights. So we'll discuss one by one. We have different types of IP. We have trademark, design, copyrights, patent, utility model, and trade secrets. Now, how one IP, how different type of IP are integrated in a single product. If I'm talking about a washing machine, so we are using different brands of washing machine in our houses. So here I'm taking an example of Godrej washing machine. Now, if I'm talking about the brand, if I'm talking about like Apple iPhone, Samsung, Nokia, Godrej, so these all brands come under the trademark category. So if I'm talking about the brand, if I'm talking about the word mark, if I'm talking about the logos, so you can protect under the trademark category. You cannot patent the brand names. You can protect only under the trademark category. And the trademark rights are given for the brand for the 10 years. After 10 years, you have to renew your certificate. Okay. When we comes to the technology, when we are saying that we have made an automatic washing machine where we have sensors integrated. So now this washing machine is automatically washing your clothes. So because we are using fuzzy logic system, we are integrated the sensor in this, and we have upgraded the technology in the washing machine in one single product. So it means we can file a patent for the same. So we can file a patent for product as well as for the process. Fine. Now these are the rights which are given to the inventor for 20 years. 20 years you can enjoy your rights. After 20 years, you have to maintain, you have to renew, you have to give the maintenance fees to enforce you to pay, keep your patent live. Fine. Now, when I'm talking about the design, okay, like suppose I have a design, I have a bottle in my hand and I have two bottles in my hand. Now, if I'm talking about the designs of this bottle, because these two designs are very different, because this is square shape and this is circular. So when I'm talking about the design of any product, so you can protect under industrial design. So industrial design protect no technical input, but only the outer shape, 2D shape, 3D shape, any shape that you want, you can protect under the industrial design category, right? Next, we have the copyright category. In copyright, we can protect the literary work, like you have made a website, you have drawings, you have paintings, you can protect under the copyright category, right? You have made any blog, you have made any article, now you can protect under copyright. You cannot patent it because there is no technology in this article. Now, if you have developed any painting, any sculpture, okay, now you can file under copyright category. Next, lyrics, sound recording, albums, videos, all you can protect under copyright category. The fourth one is a software algorithm. Software algorithm, when I'm talking about the Paytm app, PhonePe app, Google Pay app, okay, these are apps. This is no hardware integrated in this. So if I'm talking about the software algorithms, you can go for copyright, not for patent. But for patent, the patent office say you have a hardware plus software. If you integrate both the things in one device, then you can file a patent for such software algorithm included the hardware system, where you can integrate this thing in a device form, in a system form. Here I am giving you example of a diabetic check monitoring device. Okay, now you have a diabetic monitoring device in your home, where you have a small pinch of blood on that strip, and within a second you get the reading, okay, that what is the glucose level in your blood. So this is a perfect example of software plus hardware, the integrated device or integrated system for diabetic monitoring check. Okay, so here I have given that now if you have an idea in your mind, so it doesn't mean that you only can go for patent, but it can be protected under design also, it can be protected under copyright also, or it can be go for trademark and patents. Next, World Intellectual Property, you know, it's an organization which take care about the international applications. If I'm talking about the national patent, if I'm talking about the national patent, only you have an option, like you have a patent office. Like in India, we have a patent office. In South Africa, you have a patent office. But when we are talking about the patent application internationally, okay, in internationally, you can choose the WIPO route, where with the use of PCT application, you can file your patent application in India or in your country, as well as in other country within the 12-month time of period. Now, why registration of IP is important? Why we have this mentorship? Why we have this platform? Why? Because for an inventor, the invention are very important. Registration ensures that IP rights are legally protected and the creator officially recognized as a creator. Registration allows the creator to enjoy monopoly rights over the creation that I have already told you. Trademark rights are given for 10 years, design rights are given for 10 years, and patent rights are given for 20 years. And for 20 years, you can enjoy your rights. Third, it excludes, after having a patent, it excludes other from using your technology, using from copying, manufacturing, or selling. That you have stopped that second party or third party, that you cannot use my invention without my permission. And if you use my invention without my permission, I can sue you in the court. I can send a notice, legal notice to you, that how can you use my work without my permission? So that is why IP rights are important. The creator has a liberty. What is the importance of IP again? The creator has a liberty to sell or license his creation. How? Suppose I have developed a pen drive. Suppose I have a pen drive in my hand, and if I get a patent on this pen drive, then how this pen drive can be useful to you, how it can approach to you. Because when I file a patent, I found out the companies who can manufacture this pen drive, and in return, they will give the royalty. In return, they give money to me on when I license my technology to some company. So we have exclusive license and we have non-exclusive license. Exclusive license, like I transfer my all rights to one company, or I have like I can give a manufacturing rights, or I can give the selling rights to some company. So there we have an agreement between the company and the inventor. Now, what is a patent? It's a legal document that is given by the government. They are giving for your product and for your process. Like product, you have a mobile phone, you can have a patent on that. And the process of any embedded in this, you can file a process for the patent. The time period is 20 years and they are confined with geographical limit of country. Geographical limit of country means patent rights are territorial in nature. If you are from South Africa, you file a patent in South Africa, it means they are only protected in South Africa. Now, if you want to file your patent, same in India, from after filing in South Africa, now you want to go this patent in India. So again, what you have to do, you have to choose a convention application or you have to choose a PCT route. Okay. So it doesn't mean that you have a worldwide in IPR rights. There is no such word called world patent. So please keep in mind that patent rights are territorial in nature, right? Now, what is the benefit? Like you can rent it, you can license it. Patent, to get a patent, what is the subject matter that you have to keep in mind? First, the novelty of the invention. Second, the inventive step. And third is the industrial application. How? Like suppose you have developed any product. Okay, so like I'm taking an example of electric kettle. Okay, if electric kettle is already there in the market, then how can you get a patent on the same thing? You do not get the patent on the same thing if it is already existing in the market. Now, if you want to file a patent on electric kettle, you have to show something different from the already known inventions which are already in the market. If you prove the patent office that electric kettle is already in the market, but I have developed something new, some more improvement in this electric kettle, only then the patent office will give the certificate on the same invention. Okay, so there is, to avoid the duplicacy of the invention, the patent office will check whether your invention is novel or not, or it will meet the criteria like novelty, inventive step, or industrial application. If the patent is meeting all the criteria, then only the patent office give you the certificate on patent, right? Now, what cannot be patented? Any discoveries. Okay. So there are certain things which patent office do not allow you to get a patent. Like for example, discovery. Discoveries are not patentable. Scientific theories like addition theory. Okay, these are not patentable. Mathematical method, mathematical equations, again, they are not patentable. Any programming of computer programming I'm talking about, if computer programming is there, you can get a copyright, but you cannot patent. But if you embedded a hardware in this, then you get a patent on system type.
Hello, Pooja.
Yes.
Sorry, can you help me to begin to round up? Sorry. Then we'll take the Q&A after now. Thank you.
Okay. So is my voice is audible, Juliana?
Sorry, you said?
My voice is audible?
Yes, yes.
Okay.
Thank you.
Is my presentation is going okay?
Yes, but what I wanted you to do was to like comment on their presentations. That's the presentations that the mentees have made.
So, okay, yes, like I have to comment on this presentation. Okay, fine.
On their presentations. Thank you.
Okay, so okay, that's Juliana has already told me that they have already given a presentation like group 1, group 2, group 3, and group 4. I think group 4 has made a very good presentation because they have covered everything like intellectual property rights and with their examples, and they have basically started with patents. What is patent? What is a trademark? What is a copyright? Like Spotify example, and different design also, because you know, when we are going to have a presentation to the audience, the first important point that we have to start from the basic. Okay, so basic is very important, because if you go with a very, you know, high type of technologies or high type of examples, the student will don't get a you know, they will always think that from the ground level you can start the intellectual property right. What is IPR? What is in your mind? We have different types of IPR with a very good examples. So I think the group 4 has made a very good presentation. Okay, Juliana, as you told, we don't have to give any presentation. Okay, I don't mind. But I want in future we also present something to you so that you can get out the difference from the invention. You can get out the difference from the presentation, what is lacking and what improvement you have to do on your presentations. Right?
That's very true. Very true. Yes. Thank you. Thank you very much, Pooja. So I think that I understand what you're trying to do. What you're trying to do is to make a more elaborate presentation, yes, so that you can know what you missed in your presentation.
Yes.
Yes,
With
thank you very much.
With the more case studies, which are, you know, like if I'm talking about the designs and if I'm talking about the trademarks, so you pick more case studies which are related to like Starbucks. Okay, so I'm giving one example of Starbucks. Starbucks, you know, it's already trademark registered. Then India is one of the copycat of comes in the market. That is the name that we use on the product is Sardar Bush. Okay, Sardar Bush. So Starbucks is already registered. So Sardar Bush is again the copycat of Starbucks. So they filed a case against that. How can you use that name? We have already registered. So in that case, they have to pay a very huge amount as a damages, and they have to remove that name. So these type of case study, when you keep in your presentation, the audience will get a very good picture that how your IP is different from the other things.
Thank you. Thank you so much, Pooja. So let's hear from our second mentor, Mr. Max. Thank you so much, Pooja. Mr. Max has been a mentor since 2021, and we're excited to also have him speak to us today. You're welcome, Mr. Max.
Yeah, thank you very much, Juliana, as always. It's always a delight and a pleasure to be here. And let me start, first of all, also by thanking Mrs. Pooja for, I love the fact that her presentation here really helped us to establish some of those basics and foundational issues of IP, because just like Ms. Pooja rightly said, without getting those foundations right, it's difficult to really get to understand the more complex parts of IP law. It's a delight again to see you, Mrs. Pooja, and I'm so glad you are the one on the panel when we're talking about the inventors, because I know Mrs. Pooja does a lot of work in patent, which is one area where, unfortunately, in Africa, in Nigeria particularly, we are not too well developed. Unfortunately, I know I've had discussions with Mrs. Pooja before about patent drafting. It's one area where, unfortunately, we have not done too well in Nigeria, because unfortunately, our patent registry in Nigeria does not examine patent applications. They simply grant them as of course. So whatever you file, a paper you submit to the patent registry, they grant it without really considering if indeed what you have filed is patent worthy or not. Sorry, just give me a minute. I just want to switch my, okay, no, I think it's good. We can continue. I hope you can hear me clearly.
Yes, sir.
If I wanted to switch my internet source, but since it's working, there's no point fixing what is working. So I'll just quickly make comments on some of the presentation of the groups. And first of all, I want to start off by congratulating all the groups. You guys did fantabulously well. I know somebody had told me before in the course of this mentorship, as I'm always praising the mentees, and I always seem to kind of flatter them. But the truth is, I'm not flattering you guys, because personally for me, my journey in IP, where I began from in IP, was really the rock bottom. So anytime I see people making an effort, I'm always impressed, because I mean, where I started from, most of you have already far exceeded me. I like always tell people jokingly, but it's true. When I started, the first time I ever had an IP issue, I was asking somebody, how do I copyright my patents? That was how ignorant I was about IP. So typically, so when you hear me praising you, please just know it is genuine and sincere. It's because I started really from rock bottom. So I always appreciate when I see people already making an effort and already getting somewhere there. So thank you all for your presentations. They were really wonderful. And just by way of comment, the first presentation by Group 1, Mr. Femi, you thought you made a mistake, but actually something you said there really for me was very correct. You were trying to say, IP rights arise from the fruits of the human mind, but you mistakenly said human rights. But you are not wrong, actually. So because there's a strong aspect of human rights to intellectual property, because just like any other property, the Nigerian Constitution in Section 44 guarantees the right to own movable or interest in immovable property. So intellectual property, for instance, is a species of property that we call movable property. So you have a constitutional right to own your intellectual property. So there's actually a case I've handled. We didn't ultimately go to court, but part of what was in contention in that case, and the argument we wanted to make was that by the government infringing on my client's right in the way they did it, what they did in essence was that they were confiscating his right, or his copyright in that material, and that by doing that, they were actually compulsorily acquiring his right without providing compensation for him as provided under the Constitution. And we're going to pursue that matter not as a regular civil case, but as a fundamental right enforcement procedure proceedings, which would have been a quicker and faster way to get judgment for him than using a regular court case that takes longer and long. So just wanted to drive in that point that there is actually a strong human rights context to intellectual property. That it's part of the inalienable a work that qualifies for intellectual property. You have actually exercised pride of enjoying the benefits of that right. Just like if you own land, the government cannot seize your land and give it to another person without compensating. So it's also the same exactly. So I wanted to make that point that you were right. And then both, I believe Group 1 and Group 3 touched on something also I want to comment about. Group 2, of course, was talking about engineering and mentioned some things about the aviation industry. I believe Femi also touched a little on the aviation industry and said something which I think is also important to note, that in the aviation industry, we have a lot more collaboration in terms of how they manage their intellectual property, unlike in the automobile sector, where we have more competition in respect of how they manage their intellectual property rights. Yes, you are very right about that. And one of the reasons why that is so is because of regulators. So in the aviation industry, there's a lot of tight regulation. And for the regulators in the aviation industry, their primary concern is safety. So they are not concerned about your individual, you as a company, the aviation sector, Airbus or Boeing making money. What they are concerned about is how is the whole ecosystem of aviation going to be safe for everyone? So if you have a new way, you invent a new way that makes flying safer, then the regulators are more concerned about making that knowledge available to your competitors so that they can also have more safety in their flying machines than you just protecting your right and making money out of it. So that is why you find that in the aviation industry, there's a lot more collaboration than competition, because somehow that industry is an industry that is founded on very tight margins of safety. So if everybody's going to be safe in that industry, then you need to share knowledge, you need to share your inventions. And all. Of course, there's still a role for protecting your intellectual property rights. So a lot of the collaboration is not done for free. It doesn't mean that if Boeing or Airbus designs a new safety feature, for instance, that makes their airplanes safer, it doesn't mean the other person, can just go pick up that invention and use it. You might have to get what they call a FRAND license. A FRAND license is a license that's issued on fair, reasonable, and non-discriminatory terms. So it means you are paying for it, but you are going to pay a fair amount of money. And then there's a mechanism that works out how that licensing is done to ensure that at every point in time, every new technology that ensures safety in the aviation industry is available to all players, at a fair price in terms of the licensing cost. So that's also important to point out. And then I think Group 2 touched on broadcast and cinematograph works and the fact that they are covered by copyright. Yes, you are correct about that. So broadcast essentially just means the wireless communication of audiovisual signals, through mass dissemination. So covers everything from radio, television, cable, satellite network, and to a large extent also the internet is also covered by the broadcast rights of copyright owners. Cinematograph works cinematography is an archaic language. So I usually like to break it down for people. Just simply say video. Once you just say video, you're home and dry. The reason why the word cinematograph, difficult word, and sorry, I keep tripping over it. But the origin of that word was because initially when videos were made, videos were not what we think they were today. Videos
Okay, so I guess that this would be like the right time for him to maybe switch the network that he was talking about earlier. But I trust that we've been able to learn a lot already from the discussion. I'll just post the questions in the chat box so that while we wait for him, maybe we can begin to answer the questions. Okay, so so probably he would be joining us back, but there are some questions in the chat box. I'll read them out, and then if by the time I'm done reading them out, he's not back, then we'll ask Boja to begin to answer some of the questions. So the first question that we have here, we have that Mrs. Poja, the questions are in the chat box. Apart from the general procedure for registering patents, is there any special method for registering inventions relating to a particular field of study, e.g., engineering, medicine, and pharmacy? And then the second question is, what IP rights and exploitation can be enjoyed by food engineers? Okay, Mr. Marks is back. Okay, so you can continue. I was just reading out the questions in the chat box.
Okay. My apologies. I should have switched my internet source earlier. I did not, and I got punished for not doing that earlier. Yeah, so I was talking about cinematographs. Like I said, that's video simple. So that's a simple way to understand it. Audio and visual, both the pictures and the sound together, is what we call cinematograph. I think that's that. Then there's some questions you had directed to me earlier, Juliana. Maybe I could just touch on them briefly.
Okay, yes, you're already in the chat box.
Okay, those same questions are in the chat box.
Yes. So you can just respond to them and then.
Okay, then Mrs. also takes. Okay,
sir.
Excellent. Okay, thank you. Yeah. So the first question was whether there are other registration requirements or mechanisms for inventors beyond the patent. So I've already touched on that in my first answer. So I wouldn't call them registrations necessarily, but there are requirements of the law that impact on how you enjoy and you hold and enjoy your intellectual property rights. So I would mention, for instance, things like I mentioned earlier, for the aviation industry now, the regulators of the aviation industry ensure that there's knowledge sharing. So if it means there has to be a compulsory license, like I said, under FRAND terms, then they do that. But some of the common ones we know in Nigeria that would make sense to you immediately would be Standard Organization of Nigeria. So you could have an invention, it could be a car or anything, but you would have to fulfill some requirements with the Standard Organization of Nigeria called the SONCA. That is Standard Organization of Nigeria Conformity Assessment Program. So you need to ensure that your technology complies with the standards applicable in Nigeria. So that could have some impact on your inventions. There's also, of course, for pharmaceutical products and medical products, NAFDAC, which I believe we all know. So NAFDAC is National Agency for Food and Drug Administration and Control. So they have some measure of control over your inventions so far as they are related to medicinal and pharmaceutical or food products as well. So it means you have to register with them. So in other countries, and I'm sure Mrs. Puma will tell us more, if they have in India, they have what they call patent grant extensions. So what patent grant extensions do simply is that where in addition to your patent right, you need government approval to put that patent into work. For instance, you design or develop a new drug, but before you can launch that drug into the market, you need it to go through clinical trials, you need to go through approval of the regulators. Exactly, and there's a delay in getting you that approval. Then a patent grant extension simply means that you are allowed to add some more time to your patent at the end to compensate for the time you lost waiting for regulatory approval. In Nigeria, we don't have a clear-cut policy for that in our patent law, but the amended Patent and Designs Act is hoping to bring that into play. So then, of course, another regulator that also has an impact on your inventions. Group 3 spoke about engineering and broadcast equipment. So for instance, the Nigerian Communications Commission also regulates broadcast equipment and broadcast technology generally, including managing frequency and spectrum. So they also have some level of impact on your invention. So for instance, the 5G technologies or 6G technologies now, it's a bunch of technologies, different patents and all of that. But if you have any patent within that bucket of 5G technology rights, then you mandatorily have to license them under FRAND terms or under the auspices of the NCC, because the NCC wants to ensure that the technology for communication is made available to all players, so that if I use my Samsung phone to call your iPhone, they're able to communicate with each other. So to ensure that that happens, the regulator ensures that the different technologies and patents and inventions are able to interoperate and connect with each other. So these are three practical regulators that have an impact on your patent and that you might have to do some form of registration with, in addition to getting your patent right. Then for the second question, talks of IP rights in food engineering. So I mean, IP rights in food engineering, all the IP rights you have mentioned apply very fully to food products and to food engineers. So copyright, of course, so many things, even menu, for instance, you can have a copyright of your menu. Of course, the only thing you need to understand is that the fact that you have a copyright over your menu does not mean you can stop people from implementing that menu, which is why you must understand that copyright protects the expression, not the ideas. So the idea of putting rice together, putting tomato and all that and coming up with jollof rice is itself an idea. But what is protected is your expression of that idea, not the idea. So you can't prevent people, for instance, from picking your menu and implementing that menu and coming up with that sumptuous dish that you have imagined. But of course, somebody cannot take your menu, for instance, from a restaurant, photocopy it and begin to use it to sell food that's not coming from you. That would be an infringement of your copyright, of course, in addition to passing off and trademark infringement as well. So there are other unique areas. There's a case actually where a person who made cake was able to say, look, my cake is a work of sculpture protected by copyright, and therefore you cannot copy my cake. And if you do that, then you have infringed on my copyright. So that's also possible, even though it's arguable. There's an argument of saying a sculpture to qualify for copyright protection has to have some permanent nature. But however, there's a case, I believe, from Sweden or one of the Scandinavian countries that says even ice sculptures made from, icemen made from ice that would thaw once the sun comes out is liable to, to get copyright protection. So I want to believe that a cake has some permanent nature as well, even though, of course, it will be eaten by human beings, but before it is eaten, in between that period, it has some right as well. So that means there's copyright protection for that. Then I'll just move quickly. For trademark also, trademark, the brand of the food product is protected by trademark. This, in other countries, and maybe Mrs. Puja will tell us more, I don't know, but in Nigeria, we don't have clear law providing for what we call smell or aroma marks. But in some other countries, they've allowed that you can register the unique smell or aroma, for instance, of your food. But in Nigeria, like I said, it's still a little bit dicey. Another important area where trademarks comes to play in food engineering would be in what we call communal marks. So for instance, people who prepare certain kinds of dishes could decide to band together and register maybe a certification mark. So for instance, you know what they call halal. Halal is food that doesn't contain pork and other things that are contrary to Islamic law precepts. So the fact that you have that halal brand on your product is assuring people of the Muslim faith that your food product complies to their religious standards. So that is also a certification mark that comes in form of a trademark and could also be used for, by food engineers just to show that their food contains certain unique ingredients that are beneficial or comply with certain requirements. And then, of course, the other question was intellectual property rights, the economic benefits of intellectual property rights in virtual reality. So what I'll just say about this to move on quickly is that any industry that relies on research and development needs intellectual property rights, because research and development essentially is you sinking money into developing a new product or a new idea. And if you finish developing that product or idea and your competitors can simply pick the result of your development and use it, then it means you'll be losing money you have invested in research and development. So what intellectual property right does for you is to ensure that after you have labored, spent so much money to develop a new virtual reality or augmented reality product, people cannot just simply walk in, pick that product and just enjoy it for free without going through all, without paying you something reasonable as in form of a license or taking your permission, to use that product. Then the last question was employment and employment for, employment in the possibility for employees who invented in the course of employment getting benefits from the royalties or from the commercialization of their invention. So yeah, in Nigerian law, it's quite a settled question as far as the law is concerned. The practice is not so settled. So let me talk about the settled law first, and then try to bring some thoughts about what the practice should be. So Section 2 of the Patent Act is very clear that in Nigeria, because we operate what we call a first to file patent system, it means that the person who is considered to be the owner of a patent in Nigeria, who is granted a patent in Nigeria, is what we call the statutory inventor. The statutory inventor is the person who applies to get a patent. He's different from the true inventor. So it means that I could be the one who invented something, but because I'm sleeping on my right and not ready to do what I should do, Juliana goes and registers it. So Juliana will be called the statutory inventor. She's the one who has the right to go to court for patent infringement and to get damages. So even though I'm the true inventor. So the law makes that distinction between statutory inventor and true inventor. However, the law is not foolish. So what it says is that the true inventor must be mentioned in the document. So if you are picking my invention, even if I give Juliana the authority to go and register that patent, then she must mention me as the true inventor and mention herself as the statutory inventor. So for employment relationship, Nigeria, of course, draws from the common law of England. And under the common law of England, there's the presumption of law is that where an employee invents in the course of his employment, that invention belongs to the employer. However, there are certain distinctions where it can be shown that the employer did this invention in his own spare time and not using the materials, the facilities of the employer, then that invention belongs to him. But the burden would be on him to prove that I invented this not on, in my spare time, and I did not use the facilities and material of my employer. However, the law is also, like I said, why? So in section 2.4 of the Patent Act, it goes further to provide that, look, irrespective of who owns, who is the statutory inventor and who owns the patent, if an employee develops a patent in the course of his work under two circumstances, then he's entitled, even though the patent belongs to his employer, he's entitled to what the law calls additional remuneration in two circumstances. The first circumstance is where the invention or the inventive activity is not as a result of the normal scope of his work. So assuming in the food tech example we just gave now, if I was engaged, for instance, as a food biologist to develop new flavors for noodles, for instance, and in the course of doing that work, I invent a new recipe. Now, I was employed for that purpose, so I have no reason to say, having collected my remuneration, to get additional remuneration. But assuming Juliana was my assistant, who was just a lab assistant, and it is not her scope of work to invent, but she now went ahead to invent, then she would be entitled at that point, because it is not the regular nature of her duty, to get additional remuneration to her regular salary. Then secondly is where the invention is of exceptional importance. So even if I invented it and it was my scope of work, but it's of exceptional importance in that industry, then I'll be entitled to get additional remuneration. So that is the law. But the practice is that the law is a little unclear. Now, what is additional remuneration? It's not clearly specified. It just says fair remuneration, taking into account your salary and the importance of your invention. So sometimes there are no clear guidelines on how to judge what will be fair and and all of that. So, but what is important is that organizations like the University of Ibadan, for instance, has an intellectual property policy. Most universities have, where they make it, they try to make it more clear what you should be entitled to, where the university commercializes an invention you developed in the course of your employment for the university. So going forward, what that means simply is that if you are engaged to advise a client, for instance, who is developing an IP policy, then try to get them to put specifications in the IP policy or in the employee office policy manual, how people will be entitled to and what they are entitled to as additional remuneration if they invent in the course of their work. You could put guidelines that say, for instance, if your invention is commercialized, you get, in addition to your salary, you get 10% of whatever the company gets from that invention, from royalties, or you get a markup of your salary for 10% based on the commercial success of that product. So there are different metrics that can be used, but it's a matter of discussion, negotiation, and agreement. And if there's no agreement, then the court has to decide it, and it's quite difficult for the courts to decide these matters. So it's always advisable to advise your clients, guide them, and ensure you put this in paper. So thank you, Juliana. I know I've very well overshot my time, but thank you, and thank you for the wonderful questions and for the session. Thank you.
Thank you very much, Mr. Marks, for the answers that you've given. There are things that in future, when we now start getting clients, we would always remember, and it will help us in our practice. Thank you, sir. So let's hear from Pooja. I'm sure that she will have.
I think sir has already given all the answers of the questions which was asked in this chat box. But the important things that the important point I want to discuss here, like when I'm talking about food industry, like we know that food patents are allowed in India also, but we have a formulation patent, we have a composition patents, but recipes are not allowed. Okay, I think in Nigeria and South Africa also, recipes are not patentable under their act also. What about Mark? Mark, is recipes are patentable there?
Yes, the argument is that in Nigeria, recipes are not patentable.
Yes. So recipe, when I'm talking about food formulations, when I'm talking of food compositions like jam and jelly, they are patentable. But the recipe, if you are talking about, they are not copyrighted and they are not patentable, right? Now, second, the employee, whether an employee can benefit from the royalties of the invention made in the course of employment. Because, you know, Juliana, I'm working with a lot of universities, and these type of, these type of questions asked by a lot of inventors when they are filing the patent, because they have an agreement. When we have an agreement with the employer, with the university, that I am the employer and I have developed something which is used by, like, I use your R&D, okay? And when we file the patent, inventor has a right that they can file the patent by own if they have a fund, or if there is this invention is their own. But if the university has some IP policy, okay, if university has some IP policy, in that IP policy they have written that all the rights are in the hand of applicant, and applicant is the university. So in that case, they have an agreement between the inventor and between the university. Whatever they have used, whatever the image, whatever the things they have used from that university lab, so in that case, always the university will be the applicant, and half of the rights are divided with the inventor. So they have an agreement where we can have a 60-40 ratio or 70-30 ratio between the inventor and between the university or a company, so that in future there is no conflict will arises, because they have already gone to the IP policy where they have written that if any inventor come to file the patent, in that case 30% royalty will be given to the inventor and 70% will be in the hand of university. So these IP policy are very important when we are talking about the employer or employer rights, where the most of the conflict will arises, because what in India, what is happening, inventors are filing their patents without taking the permission from the university, okay? So they are filing the patent in their own name. But in future, if the university know that this inventor is the employee of our university, so they have a right that they can file a case against that particular inventor. So when we are talking about the employer or employer rights, so IP policy and the commercialization agreements are very important and play a very important role during the royalties term, right? So every inventor should know what is the IP policy, what is the IP rules, or what are the IP things they have in their university or in the company when we are talking about the patent filings. Like Marx has already given a discussion on this point. Now, when I'm talking about virtual reality, as you know, virtual reality is not a very new topic. Okay, it's already very, now the virtual reality, when I'm talking about Snapchat is also an example of virtual reality. But when we come about the intellectual property protection, in that case, the copyright is the one where we can protect, because it's a software algorithm, because in India, all the software algorithms not protected under patent, but they are comes under copyright. But if we have made any device, okay, so then we can protect under the patent category, where we have a hardware and software algorithms, both of the things. Apart from the general procedure for registering patents, like in the field of engineering, medicine, and pharmacy, in pharmacy, that Marx has already given that we have extension period of time, like 5-year extension is given to the pharmaceutical drugs. And except that, we have formulation patent, we have drug patents, we have composition patents. And in the field of engineering, we have device and process patents, which are allowed in India also, where you have an apparatus, any device, you can file a patent, and the process also you can file a patent, where the rights are given for 20 years.
Thank you very much. Pooja, is still speaking or you're done? Okay, so I guess that she's done. I think that today has been very interesting. We have actually learned a lot, including myself. I've actually learned a lot. Thank you so much, everyone. And I can see that Amosa is here, so I'll just let her say hi. Please, let's hear your voice, Amosa. Just say hi, hi, hi. Let's hear you.
Can you hear me?
Yes, we can hear you.
Hi, hello everyone. I'm here learning with you guys too.
Thank you for joining us. Yes.
Yeah, well done to the mentors and the mentees.
Thank you. Thank you, Amosa. Okay. Thank you so much, Pooja. Thank you so much for your time. Thank you for sharing from your practical pool of experience. Thank you so much. Thank you, Mr. Marks. Thank you for being there for us right from time. Thank you so much. And to all the mentees, everyone who has stayed till this time, thank you so much. Thank you, Solomon. Thank you, Faith. Thank you, every other person that is here. I want to wish everyone an amazing weekend. Take care of yourself and have a great weekend. Bye.
Thank you, Juliana. Thank you.
Thank you, Koja. Thank you, everyone.
Thank you, Max.
Thank you.
Thank you, Ms. Pooja. Really great to see you again.
Yeah, sure.
Thank you, everyone. Have a beautiful weekend.
Thank you. You too, sir. Bye.